Good afternoon, everybody. Thank you for taking your time to be with us today. This is the Michigan Marijuana Report Expert Webinar. I'd like to thank Scott Roberts Law for their support, and I'd like to welcome Scott Roberts and Nick Calkins.
Thanks for having us today.
So let me give a brief introduction. So Scott is the firm's owner and managing attorney. Scott was admitted to the Michigan Bar in 2010 after graduating from the University of Miami Law School, where he graduated with high honors. Nick Calkins is a partner and senior attorney, and Nick's background includes cannabis-based real estate issues, and he's an expert on regulatory issues involving cannabis. My name's Dan Keelan, and I publish the Michigan Marijuana Report. Again, thanks for taking your time to be with us today. Scott, do you want to give some introductory comments about the firm and what you guys do?
Sure. Yeah. So Scott Roberts Law is a boutique cannabis law firm based here in Michigan. We also do some work in Illinois. And what we do is we really just help cannabis businesses, whether it's, get them to the point of licensing and opening, helping them keep their license, advising on exits. That's our focus. So, 95% of the work we do here at Scott Roberts Law is representing licensed and soon to be licensed cannabis businesses and sometimes some ancillary real estate companies. So, when I say, this is our specialty, it really truly is. I've been working in this space for 4 years, as has Nick, which is about as long as one could be working in this space doing what we do.
Right.
And, we're just happy to, be here at the webinar and provide a little, free advice to those who are, looking to start out in the space or alternatively have kind of been there, but may need some extra help when it comes to licensing, compliance, business or real estate transactions or whatever it may be. And hopefully, we can provide everyone some really good information today.
Awesome. I'm sure that you can. So as way of introduction, let me do a quick just recap of what we're doing in media. The Michigan Marijuana Report was launched 2 years ago. We covered the industry from a news point of view with a focus primarily on Michigan and the Midwest. We cover everything from marijuana to hemp to CBD, primarily from a business point of view. In addition to that, we have a weekly streaming show called the 420 Post, which launched last summer. The show, we showcase industry news, community events, and conversations with business leaders. So if you haven't seen the show, every Wednesday afternoon at 1 o'clock, and also available on demand through our Facebook page. So before we get back to Nick, one of the things that Nick was kind enough to do was help us fashion our industry survey, which we are in the middle of wrapping up. So twice each year, we survey the industry to get a handle on trends, growth, what issues are facing business owners. And as we're winding up this survey, I'd like to just point out a couple of maybe highlights in terms of the feedback that we got. So there's the who are you question. A majority of our respondents are actually offering services to the industry. So this is important because it involves accounting, marketing, logistics, security, even law firms, right? So all of that business support that helps a new industry grow and mature. And then beyond that, the top three categories outside of the business services are cultivators and growers, provisioning centers, and CBD retail. Now, while the pandemic was, tough for everybody, we included a question about how businesses did among our readership, and we're a little bit surprised in a good way. So roughly a third of the responding businesses said they did pretty well. And when you remove the non-business responses, because some of the respondents were on the consumer side of the equation, at least half the responding companies broke even or did better. And then in terms of media, we did ask people what else we could do as a news and information organization. The top responses focused on more streaming video, people interested in podcasting, and a lot of interest in educational webinars and self-paced online learning with certification. So for Scott and Nick, the connection here is the survey revealed some areas where people need assistance, education, clarification, areas like licensing, state and federal tax policy, compliance issues, some of those around things like social equity, and general operational questions. So this is a good breaking point for me to turn it back over to Scott and Nick, who'd like to walk you through a few key areas. And by the way, anybody who's on the call, if you've got a specific question, go ahead and chat it to me. And we'll try and address it during this session. And if we don't, we'll follow up with you individually. All right, back to you guys.
Okay, thanks, Dan. This is Nick, and I'm going to talk a little bit about getting licensed in the state of Michigan. And I'll start with just a historical overview. You know, when Michigan initially rolled out this process specifically for medical marijuana facility license applications, it was pretty frustrating. Nobody envied the state's rollout of the program, but I do think it's important to note that, you know, as of today, the process is a little more streamlined, and we have a better, you know, idea of each phase of review at the state level. And also for those of you who remember, you know, kind of early on in the licensing application period, there was a board, a 5-member board kind of made up of police power, politicians, and even, you know, big industry that were making the decisions for these license applications. And that board has since been disbanded, and those decisions and that review process is now all internal with the Marijuana Regulatory Agency. So to get licensed in the state of Michigan, you have to receive both state approval and municipal approval. And it's really a 3-step process. So the way that I like to look at this is the first step being that golden ticket that we deem pre-qualification. And that is where the state is going to really kind of vet the underlying equity owners, those that have dominion and control over the business, to ensure that this type of coveted or stigmatized license is going to the right individuals or entities. And that process can take, you know, a few months depending on which regulatory framework we're looking at, whether that be the Medical Facility Licensing Act or the Recreational Adult Use Framework. And then step 2 is getting municipally licensed. And that's typically the hardest license to come by because the state of Michigan does not cap the number of licenses that are handed out. They do defer that to each municipality, which can decide whether or not to opt in or opt out to regulate these kinds of commercial activities. And a lot of the times, especially with, you know, some of those more sought after licenses like retailers, cultivators, or processors, you're going to see municipalities, if they do opt in, they're going to cap the number of licenses. And so that's going to be the hardest part, typically in the process. And then phase 3 or step 3 in the licensing process is to get your step 2 application into the state. And that's really when we're going to talk about the brick and mortar and the SOPs or the standard operating procedures of the facility. and you have the state regulatory agency and some ancillary agencies come and inspect the facility to make sure that it's all up to code and meets the administrative rules. And then from there, you're going to pay the annual regulatory assessment to the state, and you're off and running. You can open your doors. So that's a global overview. I did want to touch on some of the differences between the licensing process at both the state and local level for the Medical Facilities Licensing Act versus the Regulation and Taxation of Marijuana Act. Again, early on in the process, a lot of applications were being denied. And in part, that's due to the actual statutory framework of the two acts. It's going to be a little bit easier to get approved under the Regulation and Taxation of Marijuana Act. In part, this is because the Medical Facility Licensing Act was legislatively promulgated. So those who wrote the law may not have been too keen on cannabis in general and didn't have a lot of that foundational knowledge. Whereas the MRTMA, which governs the adult use commercial activity, was more of a grassroots ballot initiative that a lot of individuals who already had participated in the industry were actively involved in when writing the legislation. And so I think one of the key aspects to look at for individuals who are looking to get into this business and are wondering, hey, am I able to get licensed by the state of Michigan? If we look towards the recreational statutory framework, you'll see that a lot of the prohibitions that are included in the Medical Facility Licensing Act are just not there. And one's criminal history is not necessarily a deterrent when it comes to getting licensed under the adult use framework. So I want people to be really cognizant of that. And hey, even if you may be prohibited from getting a license under the Medical Facility Licensing Act, don't shy away from exploring whether or not you have the potential to get licensed for adult use commercial activity. And then the other point to touch on there is under the newer act, the Recreational Act, you don't have to show capitalization to the state. So for the Medical Marijuana Facility Licensing Act, depending on what kind of license you're applying for, you have to show some kind of capitalization. 25% of that number has to be liquid. Any other 75% can be non-liquid. And that's verified by an independent CPA attestation that is submitted in conjunction with your application materials. That was another barrier to entry for a lot of people in wanting to get into the industry, perhaps transitioning from the caregiver market to this new commercial market. And those capital requirements ranged from low six figures all the way up to $500,000 per license, which I think prevented a lot of individuals or entities from applying. And that's just not the case under the Recreational Act. So again, if you weren't able to submit an application, either pass the background requirements and or show the financial requirements for medical, don't shy away. This may mean that you have an avenue to still pursue commercial licensure in the state of Michigan under the recreational statutory framework. Other than that, like I said, the state process has gotten a lot more streamlined. I think that as the state of Michigan evolves and develops, they will become faster and better at getting those applications vetted. In fact, under the Recreational Act, there is a timeline by which they need to abide to either deny or issue a license. And we're seeing that implemented. And right now, the process from the time of submission of the application can range from anywhere about 30 to 90 days, depending on the docket and the backlog at the state level. And of course, a lot of it has to do with the complexity of the application, how many supplemental applicants are going to be included. And those supplemental applications are required when one is either more than a 10% owner of the business or has the decision to implement policies and really have dominion or control over the business. And then I just want to touch on briefly the costs of the application process. The state level requires a $6,000 application fee. That's non-refundable whether or not they approve or deny the application. And then the municipal costs can be up to $5,000 statutorily. And we kind of see a broad range there. I would say more often than not, the cities, villages, or townships will try to charge the entirety of the $5,000. So that'll give you some sense of costs involved. Of course, there are going to be other third-party professional fees like attorneys, perhaps accountants, architects, and design firms for the actual site plan, survey, and build out of the facility is going to be fairly costly. But again, something to explore if you had kind of been hindered from applying under the Medical Act and want to look towards getting into this industry. I would look towards the recreational statutory framework.
So this sounds a little complex for civilians, right? For people that don't have your background. Do you have people coming to you that try and kind of plow through all this on their own and then run into trouble?
Definitely. So, even when we started doing these applications, the way they're laid out is fairly confusing. So we have a lot of clients that'll come to us that have submitted the application. Maybe they've gotten a notice of deficiency at the state level and say, you know what, we just want you to guide us through the process and kind of take it from here. And we'll clean it up for them and then, get them through the curative documentation and just take it all the way through at the state level from there.
All right, that's awesome. And then I know you guys also wanted to talk about your focus on real estate.
Yeah, so, real estate in a lot of ways is kind of like the keys to the kingdom when it comes to licensed cannabis facilities. I also, describe it usually as kind of the biggest bottleneck that these companies face, because not only do they have to get a piece of real estate to site their facility, but they also have to only get it in certain municipalities and only certain places in those municipalities. And sometimes it's often the case actually that the municipal license is harder to get, or there's a lot more hoops you have to jump through on the municipal level than there is at the state level. So, generally, let's just say, you have a piece of real estate and you want to do a cannabis facility there. What do? Well, the very first thing you do is you see if the municipality has opted in. And that's kind of like an industry term or a term of art, opted in. But what it really means is that municipality has passed an ordinance saying, we are allowing, XYZ type of facility in our municipality. There are places that will, allow grow facilities, but won't allow dispensaries. And there's places that allow dispensaries, but won't allow growers or processors. So generally the first step to take when, evaluating a piece of property is to see, does this municipality even allow cannabis businesses? Assuming in, our example that they do, the next thing to do is look at the zoning ordinance. Typically when a municipality opts in, they'll do it with two ordinances. The first is generally referred to as a licensing ordinance, and that sets forth, what type of licenses they're allowed, how many, and any restrictions that they may have. They may have operating hour restrictions, they may have additional security requirements, or any number of kind of additional regulations on top of the states. And then in addition to the licensing ordinance, they have the zoning ordinance. Every once in a while in smaller municipalities, they'll lump those two ordinances into one, but generally that's done separately. And the zoning ordinance determines where you can cite certain types of cannabis facilities. So kind of coming back to our example of having a piece of property and deciding what you can do to it, the first thing to do is look at zoning and setbacks. So, let's just say you're in a municipality and they're saying we only want these in industrial zones. And specifically, we want them in M1 and M2 industrial zones, but not M3 and M4. So when evaluating a piece of property, the first thing you do is you look up the zoning. And then you compare that to the zoning ordinance to see, all right, is this the proper zoning designation for this type of facility or not? Once you do that, you also 99% of the time have to go through what's called setbacks. And setbacks are, the most common one that's actually a default under state law is you have to be 1,000 feet from a school. And that setback is near universal. There are a couple of municipalities that have it less, but 1,000 feet from the school is a near universal setback. But municipalities also have additional ones. In some places, and this is different for each municipality, some places may have a setback from a park. Some places may have setbacks from churches. Some places may have setbacks from licensed daycare facilities. It's whatever, I guess, the citizens or the township trustees or city council people are concerned about. And those concerns aren't, universal. In some places, churches are big, and in some places churches don't matter. And, the same can be said with parks. Public housing is another one. There's a lot of them. And really what you got to do is go through and, see what's around there and measure the distance between your property and whatever exclusionary setback is in place. Two things on here, just kind of, I'll call them pro tips. The easiest way to do this is actually Google Maps. They have a measuring tool. And when we do this, generally that's what we use. So that's something to take note of. And then number two is not all places measure the setbacks the same way. So you may think, all right, I'm going to draw a line on Google Maps from my parcel to the school, and it's 700 feet away, I'm excluded. But that's not always the case, because some will actually take the setbacks and measure them essentially down the roads. So if you're 900 feet away, but you're kind of at an angle such that you kind of got to go like north and then directly west and kind of almost like ladder your way up, then that could be, 1,400 feet if you measure it that way, but only 900 feet if you measure it as the crow flies. So this is something that's generally in a municipal zoning ordinance. Sometimes it's not in the cannabis specific one, but it actually is in there in other places. But, take note that measuring setbacks actually varies from municipality to municipality, and it's not always the same. One place may go parcel to parcel. Other places may go from the front door to the other front door, and other places will just measure it along with the public right-of-ways. So that's just something to kind of keep note of. So now let's just say, all right, you've done all that homework, and you see, hey, this piece of property, I'm going to get a premium on it. I may not want to operate a cannabis facility. There's a lot of work there and a lot of headache and a good amount of money. So, you may decide, it's better for me to just sell it or lease it. And, a lot of times that is actually a good move for certain people, because, you can let someone else deal with the headache, but still make a good amount of money. And what you see is, with properties with these cannabis zoning designations that say, you can have a grow facility here or a provisioning center there, those properties are at a premium. In the case of the dispensaries, it's usually a fairly significant premium, sometimes 3 to 5 times the actual underlying market value of the property. And, same goes with leasing. A site in Warren that maybe was leasing at $6 a foot, if there's, the ability to get a cannabis cultivation license there, that might go up to $15 a foot. While, those premiums may not last forever, at least probably on the cultivation side. You know, they are existent and they have been there since essentially the inception. So, you know, there are a lot of people in this industry that aren't actually operators, but what they do, they're essentially real estate developers for cannabis. And those people, for the most part, I won't say make the most money. There's a lot of money to be made in real estate. And that's true generally, but also very true for cannabis specifically. Well, let's decide now that you don't want to just be a landlord or, you know, flip the property, but you actually want to build it out and operate it. You know, that's going to take a lot of money. You know, cannabis build outs for cultivation, you know, common metric we use about maybe 140, 150 a foot for a good build out. And if you have a, you know, 10,000 square foot property, that's a significant amount of money. You're looking at $1.5 million to build it out. So what do? Well, you know, there's two kind of main financing options that we deal with here in the cannabis industry. Generally, a traditional bank loan is not one of them. And until the SAFE Banking Act passes, hopefully soon, that will continue to be the case. However, there are private lenders in the industry. And these are companies that focus almost exclusively on lending to cannabis companies or have developed a pretty substantial niche in lending to cannabis companies. What these loans look like compared to traditional bank loans is that, you know, the interest rates are a lot higher and generally the terms aren't as favorable. And that's just simply because, you know, you're dealing with private lenders that may not have as deep pockets and they have lots and lots and lots of people that want their money. So because of that, they can afford to be choosy and they can afford to, you know, stand firm on certain terms. And, you know, they can also afford to have a 12% interest rate when if this was a regular business, it may only been a 6% interest rate. So, you know, there are lenders in this space. I think that's a common misconception. People think, oh, banks don't lend, so no one lends. It's not true. There are private lenders. But because there are so few and there's so much demand for their dollars, the terms on these loans aren't the best, at least compared to regular businesses. And because of that, you know, a lot of times people will use what's generally referred to as seller financing. Here in Michigan, we a lot of times call that a land contract. It doesn't always have to take the form of a land contract. Sometimes it's a sale and a mortgage back. But essentially, in a lot of Michigan cannabis deals, what you see is the seller will actually help finance the purchase. So if you're buying $1 million property, you know, the deal may look like something where the buyer only puts $500,000 down and then finances the second $500,000 on say a 5-year term at 6% interest rate back to the seller. And the sellers usually do this because they can generally get a higher purchase price if they do it. And hey, they get 6% interest, and that's a hell of a lot better than a savings account right now. So it's to their advantage a lot of the times. And then if you're a buyer, it's also to your advantage because if the seller's giving you 6% and the private lenders are doing 12%, obviously 6% is a lot better for you. So, you know, the financing options here in the cannabis industry aren't great. But having said that, you do have options. So when it comes to, you know, purchasing real estate, there are a lot of kind of common issues that come up. Generally speaking, you know, all the purchase agreements we do will have what's called a municipal contingency if a municipal license isn't in place and also being purchased separately. And what that means is it's very typical for us if we're looking to, say, buy a property in a municipality that just opted in to have a purchase agreement. And then as a contingency of closing, have that contingency being obtaining a municipal cannabis license. And that's something we will do unless it comes with a actual license. We'll do that for almost all our real estate transactions. And that's just a way to, protect the buyer so that they don't, buy a piece of property at a significant premium based off their ability to operate a cannabis business, only to find out that they can't. And then they're stuck having just, overpaid a substantial amount for a property that they couldn't do what they wanted to do. Another common issue is title insurance. When we were first getting started in 2017, there was essentially no companies that would openly insure cannabis title. That has since changed, and now there's a number of companies. We like to use eTitle, but there are, Liberty Title does it as well, and there's a few others. But what's key here is that you use one of those cannabis title companies. And you may ask why? Well, what title insurance is, if there's some claim against the property in terms of title or an easement or something later down the line, that title insurance protects you. It's basically insurance against that. And if you bought for cannabis use, but you did not get cannabis title insurance, what will likely happen is you will discover you don't actually have insurance, because insurance companies love to find ways not to pay. That's kind of part of their business model. And, having a federally illegal use generally is a great way for them not to pay any claim because you violated the terms of the title insurance policy. So because of that, it's very important that when you get title insurance, you get it specifically for cannabis so that you actually have insurance, because otherwise you may think you have insurance, but in reality you don't. Another kind of common thing we come up with, and this is mostly for dispensaries, but if we're representing a real estate owner in a limited license situation where there's going to be a competitive application process to get one of these licenses, a lot of times vetting the buyer is more important than just taking the highest purchase price. Because if you're in a situation where there's going to be 4 licenses issued, but there are 10 people applying and you only get your money because there's one of these municipal contingencies or the full purchase price if they get a license, then it's almost more important many of the times to go with the group that can put together the best application and not necessarily the group that's going to give you the highest purchase price. And this is a strategy we've advised clients on a number of times. There are some companies that just seem to do very well in municipal applications. And if we're representing the seller of real estate, those are going to be the companies we're going to advise to go with. And, the opposite of that is there are some companies that just, you look at that points list once they score all the applications, you just see a couple of companies that always just seem to be towards the bottom. And I don't want to, opine as to why, but it does happen. And if you're, selling a piece of property and someone gives you $5 million offer, but it's a company that you've seen just has a tendency to just really lose all these application processes, you're probably better off going with the $4 million offer with the stronger buyer than you are with a $5 million offer with someone who's most likely not going to get that municipal license. And the final point is, we have done in this industry a fair amount of what's called dual closings. And, kind of relating back to that, some of the previous issues I just talked about, there are people who will go, tie up a property on a purchase agreement, do a very long due diligence period. I've been doing this sort of thing since early 2018 for people. And I've made some people millions upon millions of dollars. I'm not going to say who, but there are definitely a lot of people out there. And they won't even close on the property. They will just get their municipal license, they have a purchase agreement, and they'll do what's called a dual closing. So they have a purchase agreement, and then they in turn get a purchase agreement for a much higher price because they have a municipal license attached now, and they'll dual close. So it's basically the person in the middle closes at the same time with both the buyer and the seller. And essentially what they do is that they profit the difference. And sometimes that profit can be very substantial, especially when it comes to dispensaries in limited license areas with a high population density. And I think that kind of wraps it up for the stuff I wanted to talk about on real estate. I don't know if there's any specific questions, or we just kind of want to move on to the next topic.
Right. Well, we did get a question that came in that's related. Let me read it to you. Given the tax benefits for communities, do you see real estate as a potential driver for communities to opt in? And if so, how can the cannabis industry support realtors in this area?
Well, I'll take that first question and say that this is something this is a point we have made to municipalities. Under MRCMA, there is extra, slices of the excise tax that goes for municipalities, but it's only for municipalities that allow dispensaries and micro businesses, and it's proportional to how many they allow. But I've definitely made the argument to a number of municipalities that even, putting that aside, having a property purchase that was $500 for $1 million, and then having a significant amount of improvements done to that property is going to raise the taxable value of that property. And that in turn, allows communities to collect more in property taxes. So that is something that some municipalities will look at. And I think also a lot of why, when they decide where they're going to site these, they'll generally take like the most rundown part of town, or that area with a lot of vacancies and such, for that purpose of, hey, we have what's essentially dead weight in a municipality, at least as far as property taxes and occupancy is concerned. And we can turn that around and make that, the shining beacon in terms of property tax amounts and collections. As for that second question, I think, what can you do to support the real estate brokers? Well, I am a real estate broker, among other things, mostly an attorney, but I do some brokering on the side. I will say, just getting that municipality to opt in, so that there are opportunities for people, existing landowners to sell or lease their properties, or cannabis businesses to, come in and, buy property, make improvements, and raise the property tax rolls.
All right, awesome. So I know there was one more area that you wanted to talk about, and that's under this business operations heading.
All right, so Nick and I are gonna partner on this one.
All right.
Just kind of trade off.
Yeah, so the first topic here is Metrc, and Metrc is the third-party seed-to-sale tracking system that the state of Michigan utilizes to track every marijuana plant and or product that flows through the regulated commercial facilities in the state of Michigan. And it's a pretty in-depth software. Any licensee, before they start operations, needs to be involved and have obtained training from Metrc. There are other seed-to-sale systems that are utilized throughout the country, but Metrc is what we use here in Michigan. It's really quite difficult to, play hide the ball with what you're doing in your facility. Plants receive their RFID tags and are monitored consistently throughout the process, whether it be, from seedling to the actual mature plant. Once it's harvested, the batches that make their way to testing, the plant material that is then harvested and either sold to the dispensaries or processors, who will then extract some of the oils and other materials from the the flowers and or biomass to put into like your edibles or your cartridges or other kind of consumption based cannabis products that are sold in dispensaries. But overall metric is the seed to sale tracking system that allows the state of Michigan regulatory authority to monitor operations in cultivation, processing, dispensaries, and even safety compliance facilities and secure transporters. I'll take it, I'm gonna just pass it over to Scott, and he'll touch on the next topic, which is trademarks and intellectual property licensing.
So this is a way that some people use to enter the Michigan cannabis industry without having to deal with getting a license or paying the significant costs that people incur to get their own facility. So as an example, I'm not going to use a client on this one because, but let's just take Cushy Punch, which is a brand. I think they're out of California originally. But they wanted to come to Michigan. What they did is, instead of spending the money to buy a processing facility, build it out, get a license, and go through all of that, what they do is they actually license their brand to other processors. And then those other processors, make and distribute the products and then pay them a licensing fee. And this is something where, a lot of times these companies are a lot more profitable because they don't have to incur a lot of the costs and, 280E tax disadvantages that a typical marijuana company has to incur. So this is something that is fairly popular. We do, represent quite a few companies that do this. And it's something that is or can be a great business opportunity. The hardest part of this, of course, is establishing a brand. Not as easy as people think. I will definitely say that. But, I think there are, companies, I can have a couple examples off the top of my head, but again, I don't want to mention specific clients that have a brand outside of cannabis that they have brought to cannabis. Whether it's an alcohol brand or a food brand or something along those lines, there are companies that have done that. So, if you have a brand that you think may play well in the cannabis industry, there may be an opportunity to actually license that to an existing processor, have them make the product and then pay you a fee for it. And on this point, I will say there has been a lot of changes with respect to MRA on these points. It used to be that, you were supposed to get, quote, MRA approval on these licensing agreements, but up until early this year, that was almost impossible. They just didn't have anyone really responsible for it. So it almost kind of go into, submit it and kind of go to the circular bin, so to speak. This is something that MRA has fixed, and they are reviewing these agreements with a good amount of detail. So you do have to make sure they meet certain parameters and they are drafted a certain way to get approval. And they will make you get approval now. But, this can be a great business opportunity for the right person. So with that, I think we can move on to banking and,
so this has been kind of a frustrating topic for both the regulators, the Treasury Department, and then also the operators. And
I will say the ancillary businesses. I've had 2 banks shut me down, even though all I am is a lawyer in the cannabis industry. But for certain banks, they won't even allow ancillary businesses like law firms that represent cannabis companies to bank with them. And then once they find that out, they don't just shut down a business account. They're going to shut down your personal checking. They're going to shut down your personal savings. They're going to shut down your personal credit card. And I say this not hypothetically. I say this because it's happened to me.
Yeah, maybe Scott might have been the better individual to take this topic because he's had some firsthand experience. But it's definitely been frustrating for our clients for ancillary businesses for ourselves. And in fact, I went to open a bank account recently for a different business that I own and operate. And one of the first questions I saw in the application was, do you derive pecuniary benefit or financial gain from the manufacture or distribution of marijuana? Which I thought was interesting. I hadn't come across that before, and I was just applying at a general credit union. So banks are becoming a little more hip, so to speak, to a lot of the money that's flowing around in Michigan derived from cannabis operations. Thankfully, there has been progress. The Banking Secrecy Act really makes it very difficult for banks and financial institutions to comply with the requirements to accept cannabis funds. And typically those banks or institutions that do have or that have allowed this kind of activity and this kind of account activity, they'll pass those costs, so to speak, on the consumer. But in Michigan nowadays, we do have a handful of banks that are more than willing to accept funds from cannabis businesses and are doing a good job at complying with the Banking Secrecy Act. I think one of the more recent banks to come online was Community Choice Credit Union. A lot of our clients have used and have been really satisfied thus far, and they're even able to obtain some financing options specifically for cannabis-based expansion. There are definitely fees that are associated with these banks that allow for the deposit and regulation of cannabis-based funds. And some banks will take, monthly fees. Some banks will take percentages of deposits that are made. There's kind of a myriad of structure that has been implemented, but you're definitely going to pay for the opportunity and privilege to be associated with a bank as a cannabis business. I see this getting better. Scott mentioned the Safe Banking Act. We're making progress at the federal level, but it's going to take some time, definitely. Thankfully, we do have a good number of banks in Michigan now that have opted in, so to speak, to allow for our operators to be a part of the regulated financial industry.
And a couple just things to add there. I do have to also mention Dart Bank, if we're going to be calling them out, because I've been working with them for several years now. They've been great to work with, and they were one of the leaders in the industry. So I do have to at least mention them. And then, with respect to ancillary businesses, there's, I think, about 5 banks right now that will specifically bank licensed cannabis businesses. But there are also banks that, if you ask, they will do ancillary businesses. I do recommend asking ahead of time, because you don't want to be like me, where you had your bank account shut down in the middle of the pandemic and you weren't able to go to the office to pick up a check, and you had all your money frozen for a month, including your personal accounts. Learned from my mistake on that one. But, there are a number of smaller banks. It's usually always small, single or location or credit unions that will do this. But there are, these banks that will allow ancillary businesses and won't charge maybe as much as some of the other banks that are cannabis specific. With that, I think we can kind of move on to our very last subtopic. And I only think we have a couple minutes here, and we could probably go on for hours dealing with the marijuana regulatory agency. I just had some conversations with some enforcement officers just this morning. And what I would say is, there are some people, whether it's lawyers or facility owners, that just like to take an antagonistic approach with MRA. And, while this is kind of getting down to personal philosophy, that is not the type of approach I like to take. I think, a business, whether it's a marijuana business or any other business, works best when it works hand in hand with regulators and lets them know about problems as they're happening. Because what you can find is when you do that, MRA will work with you to solve it. and they'll help you solve an issue. And if you don't do that, but they, find this issue at one of their many unannounced inspections, then, expect a citation to come, because it almost certainly will. So what we've found, and again, this is just my own personal philosophy, is that it's best to kind of get them involved from the beginning and have them actually be a partner with you in helping solve problems and issues as they come up, as opposed to kind of taking what I would call an us versus them approach.
And, just briefly, I would echo that sentiment, especially as lawyers. We are the bastion between the client, the operator, who is going to be really emotional in certain scenarios, and the regulatory authority. They're there, they have the oversight, they have the authority. We want to work with them. We want to give them insight as to some of the issues that we're handling and maybe how they can improve their processes as we go along. But really, we've been much more effective when trying to work with the agency. It's a case-by-case basis, and sometimes it is beneficial to give some pushback. But for the most part, a good working relationship with the MRA is going to make the operator's life, and also the attorney for that operator's life, a lot easier in the long run.
So I know we're kind of coming up against the 3 o'clock when this is supposed to end. So I think I'll turn this one back over to Dan and Mike. And if maybe there's a couple questions at the end, we can take them. But if not, I'll turn it back to you guys. I take the deafening silence to mean that there are no questions at the moment. And I do.
But you know what? There was a question, and I was muted.
Oh, okay.
Yeah. So the one question that I just got had to do with criminal background checks, and how much weight is there if you've got something in your background, and how much does it matter if that criminality is cannabis related itself?
Well, so here it's important to distinguish between the MMFLA, or the medical law, and the MRTMA and the rec law, because the kind of the review of criminal backgrounds is different depending on which law you're going under. When it comes to, let's just say you had a cannabis manufacturing felony that didn't involve distribution to minors. In that instance, let's just say it was 5 years ago, just making up a number here. In that instance, you are not actually eligible to obtain a MMFLA license. But if you look at it from the rec law, not only are you eligible, but you're likely qualify as a social equity applicant, and you may actually get a discount on your fees. So, it's treated very differently, and that's just because, the medical law was passed by the legislatures and the rec law was passed by the people, and the people are a lot more forgiving about this. But I would say kind of generally, it will depend on what that violation is for. So if it's a, felony involving distribution to minors, that's actually the one thing that would prohibit you under the recreational law. But, it kind of depends. So, each case is a little different. I can tell you generally, controlled substance violations on the rec aren't a big deal. On the medical, they can be a very big deal. But under both, fraud is a very big deal, as is anything related to kind of money laundering or tax evasion. But, we've gotten people approved that have had, old drug felony violations or assaults or any number of criminal violations. It's very much a case-by-case scenario, because, it's one factor of many that MRA will consider. So, by itself, maybe, let's just say you had some violation 15 years ago, that may not itself cause a denial, but if you also had a recent bankruptcy and a lot of tax issues, and you had a liquor license that had a couple citations on it, those issues kind of become cumulative.
Right.
So
okay,
you
great.
kind of have to look at it in the context of everything else as well.
Awesome. Well, we are going to have to wrap up. I hope Zoom doesn't close us down too soon. But on behalf of the Michigan Marijuana Report and the 420 Post, I really want to thank Scott and Nick for your time. Thank all the fine folks at Scott Roberts Law for your support, both for our survey effort this quarter and for this event. The recording of this webinar will be available on the Michigan Marijuana Report website within the next day. So mimarijuanareport.com. And please share it with friends. And any legal advice that you need,